Welcome to The Explainer. Today, we are diving deep into India's Digital Personal Data Protection Act of 2023. Now, this isn't just some minor update. It's a total game changer for how every single business in India has to handle personal data. So, if you've got customers, clients, or even employees, you really need to understand what's.
So where are we getting all this from? Well, we're basing this guide on a fantastic detailed analysis written specifically for professionals, published in the All India Federation of Tax Practitioners Journal. We've taken their expert insights and laid them out visually to make this whole thing much easier to digest.
Let's just cut right to the chase with a really simple question. It doesn't matter if you're a chartered accountant, a lawyer, a small shop owner, or an app developer. Do you handle any kind of personal data? We're talking about the basics here. Names, phone numbers, email addresses, anything like that.
Okay, so if you answered yes, and let's be honest, almost everyone did, then this new law is aimed directly at you. The old way of doing things? It's gone. The rules of the game have been completely rewritten.
All right, so here's our game plan for today. First, we'll talk about why this new law even exists. Then we'll get into the key players, the roles you need to know. After that, the new rulebook, a super practical checklist to get you started. And finally, why the stakes are so incredibly high. Let's jump in.
First up, a new era for data. To really get what's changing, we have to look at what we had before. So let's explore why this act was created and, more importantly, the timeline that every single business needs to mark on their calendar. The old system was, well, a mess. It was this patchwork of different rules under the IT Act, which just led to a lot of confusion and, frankly, inconsistent protection for people's data. The DPDP Act just sweeps all of that away. Now, there's one single unified law for everybody. The government's even calling it SARAL. It's designed to be simple, based on core principles, and written in plain language so that compliance is actually practical.
Now, the rollout here is super important. This isn't just flipping a switch overnight. Phase 1, in late 2025, is about setting up the referee, the Data Protection Board. A year later, Phase 2 brings in some new tools for managing consent. But the date you have to circle, highlight, and remember is May 2027. That's Phase 3. That's when full enforcement begins. It gives businesses a window to prepare, but that clock is definitely ticking.
Okay, let's move on to our next section, Know Your Role. This is crucial because to follow the law, you have to understand where you fit into this new data ecosystem. And spoiler alert, you're definitely in here somewhere. First up, the star of the show, really, the data principal. This is the person whose data we're talking about. In your world, this is your customer, your client, the patient you're treating, or the employee on your payroll. They are the ones this whole act is designed to protect.
Next, and listen closely because this is probably you, is the data fiduciary. This is the business or the professional that decides why data is being collected and how it's going to be used. So if you're collecting customer info for billing or for marketing, congratulations, you are a data fiduciary. And that means the main responsibility for compliance is on you.
And finally, there's the data processor. Think of these as your hired hands. It's any company you use to process data for you. We're talking about your cloud provider, your email marketing service, your payroll company, the list goes on. And here's the key. You, the fiduciary, are still on the hook for what they do, so your contracts with them just became way more important.
So, you've figured out you're a data fiduciary. Now what? What do you actually have to do? Let's break down the core rulebook and the key responsibilities you're now expected to follow. The entire act is really built around this life cycle of data. It all starts with getting clear consent for one specific purpose. Then, you can only use the data for that purpose, and you can only collect what you absolutely need. That's a principle called data minimization. You've got to keep it accurate, and you absolutely have to protect it with good security. And when you're done with it, you have to delete it. Oh, and if something goes wrong and there's a breach, you have to tell people. It's all about accountability from start to finish.
Let's just double-click on consent for a second, because this is a huge shift. The law is so specific here. Consent has to be free, specific, informed, and unambiguous. What does that mean in plain English? It means the days of hiding consent in a 50-page terms and conditions document or using those sneaky pre-checked boxes are over, done. The user has to do something clear, a positive action to say yes.
Okay, I get it. This can all sound pretty overwhelming, especially with that 2027 deadline just over the horizon. So let's make it manageable. Let's walk through a practical, actionable checklist to get you started on your compliance journey.
This is basically your project plan between now and 2027. First things first, you got to map your data. Know what you have, where it is, and why you have it. Step 2, fix your consent forms. Make them crystal clear. Then you build the plumbing, the internal processes for Step 3, letting people access or delete their data. Step 4 is all about strengthening your digital locks and security. For 5, you need a playbook for when things go wrong. That's your breach response plan. And finally, Step 6, get your house in order with clear rules and training for your team.
And finally, let's talk about why this all matters so much. This isn't just a friendly suggestion from the government. This law has some serious teeth, and the penalties for not complying are, well, they're significant.
Let's start at the very top. The biggest penalty for what the Act sees as the biggest failure, not having reasonable security to prevent a data breach, can be up to 250 crore rupees. That's a huge number.
The next tier down is a penalty of up to 200 crore. This one kicks in for 2 big no-nos. 1, failing to tell the authorities and the affected people about a breach. And 2, breaking the very strict rules around handling children's data.
And even for other general screw-ups, the kind of catch-off or not following the rules we've been talking about, the penalty can still go as high as 50 crore rupees.
But here's the thing. It's not even just about the fines, as massive as they are. The damage to your reputation can be catastrophic. You could lose clients, face legal trouble with partners, and you'll definitely be under a microscope from regulators. In the most extreme cases, they can even block your services.
So what's the big takeaway here? That May 2027 deadline is going to be here before we know it. Getting ready for this act isn't just about checking a legal box. It's a fundamental investment in your business. And more than anything, it's an investment in the trust you have with your customers.
And that really leaves us with one final thought to chew on. As you start this process, the goal isn't just to have a fancy new privacy policy document. The real goal is to make compliance operational, to weave it into the very fabric of how you do business day in and day out. So the question you need to ask yourself is, are you ready to make that happen?